Slip and fall cases present a unique challenge that doesn't exist in most other types of personal injury cases. And that challenge is this. It is very hard for most people out there to relate to what it's like to slip and fall and to suffer a serious injury in a slip and fall incident. Most people would have a much easier time to understand how a car accident would lead to an injury or some other mechanical impact that would lead to an injury. Why? Because way more people have been involved or know someone who has been involved in a car accident, and even if someone wasn't personally involved in a car accident, it's much easier for them to understand how being rear-ended, how being hit from behind, or how being hit head-on, or how being T-boned would lead to a major impact and injuries and a lot of pain than in a slip and fall situation. A lot of people will simply have a hard time imagining why it would happen, how it would happen, and why it's not your fault. Maybe it is your fault, and if it's not your fault, how is it that you couldn't prevent that injury with your hands, with your elbows, with your wrists, and why you suffered such serious injuries. Now, what does this mean to you and to your slip and fall case? This means that it is your job to come across as likable and as credible as possible during your testimony, whether it's at your deposition or in arbitration or in your trial, whether it's the jury who will be deciding your case or the judge. It is even more critical to come across as someone who is likable, for whom the jury or the judge will feel and who they will believe, than in other types of cases, because you have that initial skepticism. So what are some of the simple things that you can do to make sure that you come across as that likable and credible person? Well, there are a few things that you can do, and here is my very short list. Number one, do not demonize the other side. Do not make the defendant, whether it's the owner or the manager of the property or the premises where the incident occurred, don't make it sound like they're these evil people who created that condition on purpose so that you and other people will fall, unless there is evidence that they did something like that on purpose, which is extremely rare. Usually it's negligence, it's somebody didn't do their job, somebody didn't watch over the property, somebody didn't maintain it in a safe manner, but it was not done on purpose. It was not done maliciously to hurt you. So when you testify, whether again it's at your deposition or a trial, you don't need to make it sound like the defendants are these evil people who are in the business of making people fall and break their ankles and arms and shoulders and so forth. Number two, do not exaggerate your injuries. You do not and you should not be making it sound like your injuries are as bad as if you were involved in a head-on collision or a rollover collision. There are a lot of people out there who suffered much more serious injuries probably. So you should not elevate your injuries to that level. You should not understate, but you should also not overstate your injuries. Number three, never sound angry. Your job is to simply tell the story, answer questions, and provide the facts about how the incident happened, where were you going, where were you headed, what kind of injuries you suffered, which doctors you saw, what you felt after the injury, what you're still feeling, and how it affected your life. If you want to sound sad, it's fine. If you want to sound neutral, it's also fine. But no jury and no judge responds well to anger. It's really hard to award money, to award compensation to people who are angry. Most people are instinctively reluctant to be generous to people who show anger. So there is no benefit in being angry on the stand, and you should try to avoid it at all costs. And the last tip is avoid sounding and looking bored or disinterested. I have seen people yawning or sighing on a stand as if they're not interested in the process, go like this. And imagine you have a judge who is sitting there all day. It's not his case, and you have a jury that is not even paid to be there, and they have to be sitting there and listening to the case. Imagine how they feel about your case if they notice that you are not interested in your case. If you are bored, why should they not be bored? And if they become bored with your case, you can pretty much count on either losing your case or getting a very, very small award. And I assure you that judges and juries notice everything. They notice every little gesture, every little smirk, every little sarcasm, and every little hint of not being completely truthful, not being completely upfront. So, no sighing, no yawning, no smirking, no sarcasm, and no other gestures that would suggest to the judge or the jury that you are either overconfident in your case or that you treat the whole process as a game. I'm sure that these tips will help you in your slip and fall case, especially if it goes all the way to arbitration or trial. Thank you.